international events a month, and Tandeka and Gabriel Takatso, they very efficiently and competently run these events. So there we invite ambassadors and high commissioners from different countries, where they will give the bilateral trade opportunities that's available, and it's really a platform where members can engage and you really form partnerships and future collaborations. And we find that these events is really a great platform where members can engage. And then we also do SME development programs. We have key stakeholders like the German government through GIZ, the British High Commission, Trias, Belgium. We work with the city of Johannesburg. We also Gauteng province. So we've developed a model, SME model. We've refined it, and we've now put it in different tiers, where we have startup businesses and then training businesses for export. And there we give them all the necessary business management skills to run a sustainable business, and then export skills. Then we do a feasibility study to identify suitable markets of entry. And then we assist these chambers, we assist them by giving them connections with the different chambers globally as well. So at JCCI, we really hands-on and with the businesses, see where we can help businesses to become sustainable. And then we work with strategic partners like SLKB and other partners, where they can offer their input that assists businesses to be sustainable. And once again, I'd just like to say thank you to SLKB for this time and for this input. And I would like to invite the speaker today, Fernando Raul Lengert, who will be speaking on the challenges and pitfalls of debt collection. And as I said before, it's a very important topic for all businesses. And I thank you, and I know we're going to get quite a bit of input, and we can apply it. Thank you so much, Fernando.
Thank you, Bernadette. Thanks for the introduction. Can you hear me fine?
Yes, it's perfect. Thanks. It's perfect. Yes, it's okay. Perfect.
And the slides are still there. Okay, thank you everyone for joining us this morning. I hope you can all see the slides. It does look like it's sharing on my side. Before we begin, I'd like to take this opportunity to introduce myself and explain a little bit about what I do. My name is Fernando Lengert. I'm a partner at Spellis Lengert Kubler Brown Attorneys. I've been practicing for 15 years, and I have over 17 years experience in litigation and debt collection field. And our firm is celebrating its 10th anniversary this month. Today, we'll be discussing the challenges and pitfalls of debt collection process. And my goal is not to be too negative about the process, but to give you insight on how to manage your risk and how to improve your chances of recovering a bad debt. So if we look at the first slide, essentially the three options available for collection of debts. The first and obviously the most obvious is to collect cash on delivery, payment on presentation of an invoice or statement, or on account. However, it's not always practically possible to collect cash on delivery, but this obviously remains the most effective method of collecting payment of an or of a debt. Payment on presentation of an invoice or account creates its own problems because, generally speaking, the goods have already been delivered or the services have already been rendered by the time that the payment is due. Whichever method you use, it requires your customer to make payment to you, but what often happens, or what happens when a customer does not pay? And this is where the debt collection process kicks in. And the options available in that regard are to employ a debt collector to collect payment on your behalf. And the problem with debt collectors is that they are unregistered and largely unregulated. So this means that you either have to pay them a percentage of your outstanding debt for their services, or pay them upfront with no real recourse if a debt is not collected. So the third option, and that's what we'll be discussing today, is the collection of debts through legal proceedings. And it's, like I said, we'll be concentrating the other. Obviously, if payment is received or collected, is not an issue, and debt collectors, we won't go into too much detail. Okay, so before we embark on the debt collection, I just want to set out what the court procedure looks like. And the standard method of collecting debts through legal process is called an action procedure, which involves sending a letter of demand for payment to a customer. If no response is received or an unsatisfactory response is received, you are then required to issue a summons for payment. And this process typically concludes with a trial, which the goal is to obtain judgment against the debtor for payment of an outstanding debt. Okay, so the action procedure is split into the following stages: a pleading stage, discovery stage, pre-trial stage, trial preparation stage, and the trial itself. So as the slides that follow, they will show each stage and what's typically involved in each one. Now, the pleading stage is the stage where we set out the nature of a claim, and the other side, the debtor, has the opportunity to set out its defense to the claim. So what typically follows is the issue of a summons, with which a plea is attached to, or sorry, the issue of a summons supported by particulars of claim, which sets out the nature of the claim, who the debtor is, why the debt arose, and that it's not been paid. The debtor is then afforded an opportunity to respond to the summons, and they set out a plea and in some instances a counterclaim. So where they explain either that the debt is not due, it's been paid, and a counterclaim, for example, would be where poor workmanship or defective products are delivered. They would set out a counterclaim to say that they have a claim against the creditor, and that's why the claim has not been paid. Replication is the third document, which is filed by the claimant to respond to a plea, which may or may not be necessary, and a plea to the counterclaim if there is one. And that is the typical process, which can take between 2 to 3, sometimes even 4, 5, 6 months to conclude. So it's quite a long and involved process where the claim and defense are set out in written format, and sets the parameters for the trial. What follows after the pleading stage is the discovery stage, and this is where documents that will be used at trial to prove or disprove a claim are exchanged. Now, the South African legal system has a no surprise policy. So this means that you cannot produce mystery documents at the last moment to surprise your opponent. All documents that you wish to rely on at trial must be shown to the other side well in advance of a trial, in order for the parties to be able to accurately assess their chances of success at trial and to prepare accordingly. So it's quite an involved process where a discovery affidavit is submitted, which is accompanied by a schedule of all the documents that the person or party will produce at trial, and each side is required to submit a discovery affidavit, and that can be supplemented by the supplementary discovery affidavit. But the main point is that all your documentation will be listed and presented to the other side well in advance of a trial. So it's always important to make sure that you have all your documents in order right from the beginning, because you will need them in order to prove and successfully recover a debt. There's also an opportunity presented to the parties where they feel that documents have not been, or all the documents have not been provided. Each party is given the opportunity to file what's called a request for further and better discovery. So if, for example, an invoice or delivery note is missing, the other side can say, well, hold on a second. I can see that there's a document that you have in your possession, which is not part of your bundle. I need to access and have to have sight of that document. And each party is given the opportunity to request documents from the other side. And if any party fails to provide, there's what's called an application to compel, which an order is obtained from the court ordering the other side to produce documents for trial. This is followed by what we call the pre-trial stage. And this is a process where the formalities of the trial are agreed upon well in advance of any trial being allocated. And it presents the parties with an opportunity to request admissions, to ask questions in relation to the other side's pleadings, and it's an attempt to shorten the duration of the trial, and this must be concluded before a trial date is applied for. Now, recently, a notice has been sent out to legal practitioners from the high courts in Pretoria and Johannesburg, where at this stage, the courts want to introduce mandatory mediation, which is a further step as part of a pre-trial stage, which will require parties to submit to a mediation process before any allocation of trial dates happen. So I'll deal with mediation a little bit later in the process, but it's just now possibly an extra burden or an opportunity, depending on how you look at it. But it does seem like mediation will become mandatory in action proceedings, and it will come at this stage where the parties are then required to sit before an independent mediator and try and resolve their disputes outside of court before a trial date is allocated. This is then followed by a trial preparation stage, which is essentially the main purpose of the stage is to afford the parties the opportunity to interview their own witnesses and experts and prepare all document summaries and everything that's required for trial. And then finally, this leads to the actual trial, which follows a process of where argument is presented. It's in the form of opening statements by the legal representatives, and then the witnesses for the plaintiff, which is the claimant, would then give oral evidence, and that follows the same process for defendant, who gives his witnesses would give oral testimony. Argument is then presented by the legal representatives and eventually concludes with a judgment. There is a process in the middle there that's called absolution from the instance, which is something that's more sort of familiar with criminal matters, but obviously applies to civil matters as well, where the defendant is allowed to apply for basically a dismissal of the claimant's case at the end of the claimant's case, to say, well, you've concluded, because obviously the claimant has the onus to prove its case as it set it out. It will present all its evidence and at that stage close their case. And at that stage, the other side is allowed to apply for dismissal in the event that they can prove that the claimant has failed to set out all the elements of the debt that's owed. So it's quite a long and involved process, and typically a timeline from letter of demand up until the judgment at the end of a trial can take anything from 2 to 5 years, and in some cases even longer. So it seems like quite a short process, but it does take a lot of time, and there's a lot of delays in between. After all of this is gone through, is important. Yes, there'll be Q&A at the end of the session. So it is important it's not important for purpose of the discussion to look into the appeal stage, but I've just set out this is what an appeal stage would look like. But it's just important, like I said, to show that although you've completed the whole trial process, obtained your judgment against a non-paying customer, that same customer will still have the opportunity to appeal that judgment, and that causes further delays to the matter. So an appeal stage typically looks like this, which obviously an appeal is not automatic. The claimant has to apply for leave to appeal, and then appeals can be made to the High Court, the full bench of the High Court, then to the Supreme Court of Appeal in Bloemfontein, and then lastly to the Constitutional Court, which all those processes take their own time, and obviously delay any judgment or execution of a judgment. So if there is no appeal, you've obtained a judgment against the debtor that hasn't paid, then there's still an additional process, or two processes, which is taxation and execution stage. This is very important to understand that once you have a judgment, you'll have to proceed with taxation, which is a process to recover your legal costs. Because obviously the successful party generally is awarded a costs order, which then you're entitled to set out what your legal costs are and recover payment. However, it is important to note that legal costs are generally awarded on court tariff unless agreed otherwise. So a bill of costs is prepared, and a taxation hearing is held where a bill of costs will it's almost like a mini trial in itself, where the parties are entitled to dispute certain charges that the legal representatives have made, and eventually an award or an order is given in favor of the successful party, and they recover a portion of the legal costs. So not all of the legal costs, but a portion of it. And then in between that, so either once a judgment is granted or after taxation, whichever is preferable, is the execution stage. Now, once you obtain a judgment, the best or expected solution is that the debtor will then pay. But this doesn't always happen. So it happens that you then have to issue a warrant or writ of execution, and send the sheriff to the customer or debtor's premises to search for first movable assets, then incorporeals like bank accounts, shares, and things like that. And then lastly, immovable assets, which would be the premises of the customer or residential premises if owned by a customer. So all of this again takes its own time and incurs its own cost, as it's obviously a continuation of the legal process. Now, in between the action procedure, there's what's called an interlocutory application process. And this happens and occurs in and during a trial stage, or sorry, not trial stage, but trial process. And it is actually the most likely outcome of an action procedure in any debt collection situation. The reason for this is that when seeking a judgment for outstanding debt, most customers don't have an actual defense for non-payment. They're simply unable to pay a debt. So this results in a judgment being taken against them either by default or such summary judgment. So what would typically happen is you would send a letter of demand, again, either no response or an insufficient response is received. You will issue a summons and the debtor ignores the summons. Then at that stage, you're entitled to apply for what's called default judgment, and simply say that you've issued a summons, the time period for defending that summons has passed, which is 10 days. So if they receive a summons within 10 days, they do not file a notice of intention to defend, you can apply for default judgment and you get your judgment at that stage early in the process. And then the whole action process that we discussed falls away. You've got your judgment and you can immediately proceed to execution. The other option is that the debtor, on receipt of the summons, does file a notice to defend, pleads to the claim, and basically says, I deny everything. I deny that I'm indebted. I deny that either services were supplied or admit that the services were supplied, but doesn't set out an actual defense. And that's, for this purpose, the summary judgment process was developed so that once you receive the other side's plea and you're able to show that they're just submitting a plea just to delay the process and force you through the whole action procedure, then you're entitled to apply for summary judgment and show the court that your claim is a claim for either goods sold and delivered, services rendered, or monies lent in advance, and that you're suing for a certain or certifiable amount of money. Then you're entitled to apply for summary judgment. And again, at an early stage, you are then able to obtain judgment against the debtor, and again, immediately proceed with the execution process. So if judgment is obtained in either default judgment or summary judgment process, you immediately proceed with taxation of your legal costs, which are obviously then much greatly reduced, and proceed with the execution stage. So then another option available is there's two main forms of procedure in courts: the action procedure, and then there is the application procedure. It's also known as the motion procedure. This is not the most common or commonly used procedure, but it is an option under certain circumstances. So what typically happens here, instead of issuing a summons, you issue what's called a notice of motion, and it's supported by a founding affidavit, which is a sworn statement and includes all the documents necessary to prove a claim attached to that affidavit. And this concludes eventually with a hearing on the papers. So there's no oral evidence presented. It's just argument is presented on the sworn written statements of the parties. Now, this process is typically a lot faster. So generally we look at a full opposed application procedure lasting between 12 to 18 months. It can be longer depending on the situation. But this is only available where the claimant is convinced that there won't be a dispute of fact. So for example, I delivered goods to my customer hasn't paid. There's no dispute about whether the goods were delivered or not, or that the goods were defective. Then I can issue a notice of motion. I can say the debtor owes me X amount of money, and I can apply for judgment on that basis. obviously the debtor is then able to oppose that. And if, for example, he comes and says, yes, I received the goods, but they were defective, then that creates a problem because now there's a dispute of fact. And then this application procedure can now be referred to trial, which then falls back in the normal process. So it's only available if the claimant is convinced that there will be no dispute of fact. The basic motion procedure, like I explained, it starts with a notice of motion supported by founding affidavit. Both summons and applications are served by a sheriff. A notice of intention to oppose is received and an answering affidavit. So you've got 10 days to file a notice of intention to oppose, 15 days for an answering affidavit, which comes from the debtor, and another 10 days to reply to that, and that's from the claimant. And if once all those documents are submitted, a hearing is held, and again, it's just the legal representatives presenting legal argument based on those affidavits and nothing else. However, if there's no opposition, which is very similar to the default judgment process, you can then immediately set the matter down for hearing and apply for judgment. So the benefit of this process is it does allow you to apply for judgment at an early stage as well. And if there's no anticipated dispute of fact, it typically concludes a lot faster. But like I said, the risk is always there that if a dispute arises, that the matter will be referred to trial. And this process is used for two types of applications. The first one is what's called an application for payment, which, like I said, is essentially the same as issuing a summons for payment, but in the application format. And then the second one is the application for liquidation in terms of Section 345 of the Companies Act. And what that allows is that if a debtor owes you an amount of money not less than 100 Rand for over a period of 21 days, there's a deeming provision in the Companies Act which says that that company is then deemed to be unable to pay its debts, and you can apply for the liquidation of that company. Now, this is quite a drastic remedy, and it's not intended to be used for debt collection process. But essentially, when you're stuck with a non-payment from a customer, it can be used to apply pressure on them and try and force them to basically bump you up on the list of priority so that you get paid first. But it is a risk in that if the customer is really unable to pay its debts, that customer will then eventually be liquidated. And the risk is that, the liquidation process does not produce any results for you. It just means that the company is liquidated and you find that there are no assets to recover your debt. But it is a very good option to have if you want to apply pressure to a customer to pay you and to make sure that you are the number one priority when it comes to paying debts. Okay, and then this is just the final steps of the motion procedure, which requires heads of argument. It's all very technical, but essentially the hearing takes place, judgment is given, it can be appealed, and if no appeals made, it follows the same process then afterwards as an action procedure, which is the taxation and execution stage. Okay, so then based on what was discussed now, the problems with debt collection procedure is that, well, the three main problems is the time, the cost, and then the chances of recoverability. Now, as mentioned, a undefended action where you apply for default judgment can take anything between 3 to 6 months, sometimes longer. Defended actions, anything, we're talking about years then, and then it's typically between 2 to 5, but again, it can take longer in certain situations. The cost of a trial, whether it's in magistrates court or high court, can easily lead up to costing between 100,000 Rand upwards. And in a high court trial can easily run into the millions of rands. So in order for this to make economic sense, the debt has to be a substantial one in order to follow that whole process. The second thing is that then even if you're successful, you will be entitled to payment of legal costs by the debtor, as explained through the taxation stage. However, that recoverability is limited to the specific court tariff that you're in and is generally insufficient to cover the actual cost of litigation. As a rule of thumb, I always say that if you tax a bill of costs based on the actual cost that you've paid your legal representatives, you'd recover about a third. If you have included in a contract a higher scale, then you can recover between 50% to as much as 2/3 of your legal costs, but you never recover the actual cost. And then the third issue, like I said, is recoverability, and that is essentially the execution stage. That after all the time and costs have been incurred, a judgment must still be executed. This meaning the finding of sufficient assets